I'd like to welcome everybody to today's webinar. My name is Elise Gross, and I am an attorney of counsel to the Presser Law Firm. We do webinars once a month. We alternate between topics on estate planning and asset protection. We also have a weekly newsletter if you're not already receiving it. And if you have any questions with regard to today's webinar, you'll email them please to info@assetprotectionattorneys.com. You can email that as well if you are not already receiving the newsletter and would like to receive it, or if you're interested in a complimentary preliminary consultation on any aspect of law that we cover, and if not, we can always direct you further. If you have any webinar topics that you're interested in hearing about, please feel free to email us those as well. And finally, we have attorneys who are accomplished speakers. So if you have a group that is interested in having one of our attorneys come speak, we're certainly interested in discussing that. So please contact us on that as well. If you get disconnected, please call the office at 561-953-1050. The topic of today's webinar is the role of the personal representative and the trustee. Let me begin by saying that a personal representative and an executor are synonymous terms. So depending on what jurisdiction you might be in, you may hear one or the other. I'm going to be using the term personal representative because that is what we use in Florida. But they are the same thing, so don't get confused by that. What we'll be talking about generally today is probate versus non-probate, who the personal representative is, what are their powers, how do they become the personal representative, as well as how do they get discharged from that position. And the same for the trustee. Who are they? Who can actually serve? What are their powers? Mandatory versus discretionary distribution powers. So let's just begin with the personal representative versus the trustee in terms of their definition. So when you're dealing with a personal representative, that means that the court is involved and there's probate. Now, one thing we need to clear up, and it's beyond the scope of today's conversation, but I want to make sure we clear this up. When you have a will and there are assets that are going through your individual name, when you pass and you do have a will, those assets will go through the probate process, which is the court process to change the title from the name of a deceased person or a decedent into whomever is going to inherit. The same is said, you can have probate or you will have probate if there's no will, but there are still assets passing from an individual in their individual name to others at death. Now, individual name means there's no designated living beneficiary, there's no joint owner with right of survivorship, and it's not in trust. So then any asset that doesn't qualify under those will be an individual asset, will be subject to a court process, which we call probate. That's when the personal representative will be involved. On the flip side, you have the trustee. A trustee could be somebody who's appointed during life or at death, depending on the trust, what kind of trust it is. You can theoretically have a trustee through a will, and the way you do that is if the will itself contains a trust that gets established at death, and then a trustee is essentially appointed as part of that trust. And we'll talk a little bit about both today. But just in terms of definition, I mean, everyone can read, but the personal representative is appointed by the court, usually named in the will. If there's no will, then somebody petitions and becomes the personal representative. The trustee is generally named in the trust. If for whatever reason there is no trustee named in the trust, you'll have to go to court and appoint one. So starting with our personal representative. So the personal representative, as I said, gets appointed by a probate court. And I use the term probate court because, again, that's what we use in Florida. In other jurisdictions, it might be called a surrogate's court or some other terminology. The personal representative gets appointed after a petition is filed asking for the appointment. Regardless of whether there's a will or not, the petition has to include the request for somebody to be a personal representative. It may also include a request for the court to admit the existing will to probate. The personal representative, once they are appointed, basically stands in the shoes of the deceased. What I mean by that is that the personal representative is in charge of making sure that all beneficiaries are identified, that all assets are gathered and inventoried, that all assets that are still in existence, like real estate or a business, are kept running and not wasted, that bills are paid for anything that's related to an asset of the estate, that beneficiaries are kept in the loop through either formal notice or through mail or through email, and most importantly, that creditors are actually determined and potentially paid or objected to, but the personal representative is in charge of this stuff. So before an estate can even get started and the petition for personal representative is submitted, if not everyone is on the same page, meaning all beneficiaries are not either cooperating or not in agreement, then they have to receive what's called formal notice. And what that means is basically it's a piece of paper that says, here's a copy of the petition for administration. You generally include a copy of the will if there's one as well, and you let the beneficiaries know that they have, depending on the jurisdiction, it might be 90 days, it may be, some other number in another jurisdiction, but they have a certain period of time in which to come forward if they have an objection to the personal representative being appointed. Now, I'm doing one right now where I have that. Generally, I have consent from everybody involved, and it's pretty easy, and we can end up getting an estate opened fairly soon after the person died. But when you're dealing with formal notice, by the time you figure out that the beneficiary or interested party is not going to be that cooperative, it could take a while. Then you have to prepare the formal notice, make sure all your documents are signed so that they can be included with that formal notice. You then send it out certified mail, which takes some additional time. And then that person has whatever the allotted time is to put in an objection. So that could delay an estate by minimum of 90 days, usually by at least 4 months. So it's very important from a personal representative standpoint to know where the beneficiaries are going to stand from the beginning so that we don't have additional delays. Once that notice period is over or the beneficiary has consented to signing a waiver and consent to the personal representative being appointed and the estate being opened, the judge will issue letters of administration. And again, that's a term we use in Florida. It might be letters testamentary, it might be administrative letters, many different terms for that. The personal representative then has this piece of paper that empowers the personal representative to stand in the shoes of the decedent and be able to make the decisions and get any information necessary to deal with the estate. So, for instance, let's just say there's a brokerage account that was in the name of the decedent. It didn't have a beneficiary listed. Once the personal representative has their letters, they can then send that to the brokerage house, and they are given any and all information, and they will be able to move forward on any paperwork to liquidate out the account or change it into the name of the estate if that's what they so choose to do. Once they've figured out what their job is in terms of, okay, what are the assets in the estate? Who does the personal representative have to deal with? Is it banks? Is it brokerage accounts? Is it tenants because there's property? Do they have to engage a realtor to sell any property? Do they have to find somebody to clean the properties? This is their job. They have to do all of this stuff. They also have to inventory the assets. And that inventory becomes a formal filing with the probate court where they have to notify the court the account numbers, the amounts in the accounts, if there's a business. Now, obviously, unless you have an account statement that gives the exact amount, you're going to have to estimate values. So with real estate, when you do the inventory, which is generally due within 60 days of the estate being opened, letters being issued, you may not know the real value of the inventory. So you have to do your best to do, a simple market analysis or ask a realtor to do a market analysis. You're not necessarily going to have a formal appraisal at that point. And the reason you wouldn't have the formal appraisal is if you haven't decided to sell it yet, you need to, determine what the plan is for the real estate. And if you have decided to sell it, well, the seller doesn't usually pay for the appraisal, the buyer does. So you would kind of hope that you could get whatever price you're going to sell it for, that's really going to be your market price now, because that's what somebody's willing to pay for it. So they have to inventory the assets and then send a copy of the inventory to the beneficiaries. In the meanwhile, they've published notice to creditors and they've notified any known creditors via certified mail that an estate has been opened. The purpose here is that you can't distribute assets from an estate until the creditors have had their time to come forward, file claims. The personal representative has had the ability to either object to those claims or not if they're legitimate. And this claims period is open to all creditors. If you publish notice, which is required, that is to the general creditor population because you're publishing a newspaper. They're not getting direct notice. They have to be looking for it. But if they're a known creditor, then you will have specifically sent them what we call a notice to creditors via certified mail. Depending on your state, what the process is how long a creditor has. In Florida, it's 90 days from either the date of first publication or the later of 90 days from that first date or 30 days from a known creditor's receipt of certified mail. So if you have knowledge of a creditor and you fail to send them notice and the 90 days expires, you then have to send them notice and they get an additional 30 days from the date of the receipt of that notice. So you always want to make sure that you're simultaneously sending known creditors their certified mail during that creditor's period, so there's no extension of the creditor's period. While this is all going on and the personal representative is inventorying, they're managing all assets. So again, there could be a business involved, there could be real estate involved. They're dealing with the accountant to file any final tax returns, and they're dealing with the creditors. The personal representative can be personally responsible if they don't manage the assets properly. So if you have a rental property and you're not paying attention to the rental property and there's a problem with the rental property or the tenant isn't paying and they haven't been sued, that personal representative could be held liable for this. So they have to be very careful that they're following through on their fiduciary responsibilities. The creditors period, again, is depending on how long the creditor period is under the state law. Once it's expired, the creditors have to be dealt with. That means a savvy personal representative, if they see a bunch of creditors, a lot of claims, they're going to try to negotiate those claims to get the best possible deal for the estate. Once all the claims are dealt with, they know how much they have to pay, they know they have enough to pay it. They have to send the creditors their checks along with a satisfaction and release of the claim. You should never have a claim that does not have a matching satisfaction and release, because the court won't allow you to close the estate without it. And finally, once all this is done, the personal representative distributes all of the assets, gets signed receipts from the beneficiaries of their receipt of the assets, and proceeds to file final paperwork, which we will talk about further down. So rolling this back a little bit, who can actually be your personal representative? The answer is pretty much anyone who's over the age of 18, who is not incapacitated, can be a personal representative. If you have a will, you can name anyone you want. And if that person doesn't wish to serve, you usually will have named a successor. If you don't have a will, then generally what happens is one beneficiary will come forward and petition the court to be the personal representative. Depending on where you live, and this could vary county by county, is what happens with the personal representative's petition. In some counties, the court takes it at face value and will appoint the personal representative as long as there's no objection. In other places, they may do a background check. They may make you file an affidavit of no felony convictions. The sky's the limit, whatever the court requires, and sometimes it's individual by the judge. So you have to assume if somebody's going to come forward as a personal representative that they don't have any felony convictions. But depending on the court, nobody may ask the question. But under the law, that's the way it's supposed to be. And again, judge specific, the judge might require that in order for the personal representative to serve, they have to either put up a bond or the judge orders a restricted depository account. So what that means is that if there's a bond, it's similar to what you do if somebody's been arrested. In order for the personal representative's control over the money to be secure, so that if, God forbid, the personal representative does anything wrong or runs off with the money, the estate is secure, you could have a bond, which ultimately, generally, the estate will pay for. And sometimes it's just an extra cost that they really didn't need, because the will have waived the requirement for bond, but it's judicial discretion. So I did have a case recently in a county where it's common, and especially with a particular judge, where even though the beneficiaries were three brothers who all got along with no problem, the asset of the estate was a single asset. It was one large brokerage account. The judge required a bond of the personal representative in order for that personal representative to be appointed. And it was one of the brothers who was being appointed, and everyone consented to it. So it was $1,000 and it was a delay, but we had no choice but to move forward on it. The other option would have been to get a bank appointed to hold a restricted depository account, which is essentially an account that you can't get any money out of without court order. So that means anytime a bill would need to be paid, whether it was where there's real estate and you needed to pay a mortgage, or you needed to pay somebody to mow the lawn, or you needed to pay the attorney or the accountant, the personal representative would have no control over the checkbook. Each time a petition would have to be made to the court asking for those disbursements to be made. Very costly, very time consuming. So the bond is often a better idea because it'll save attorney's fees in the long run and it'll save time. Notice, we already kind of covered this, Notice forms in several different ways in a probate setting. It's either notice to beneficiaries or notice to creditors. In any event, it'll require certified mail so that you can have a return receipt in order to prove to the judge that you've served the notice. Sometimes what I find, and this is when you use those little green cards, sometimes I find that the item is delivered and they don't sign off on it. So the green card is returned to me, but there's actually no signature on it. That used to be a much bigger problem, but now when you can track, because there's a tracking number, you can track things with the post office, you can confirm the delivery. So you know there was no mistake. And what I do in that situation is I'll print out the whole tracking and where it went and when from the USPS, and then I will attach that to the proof of filing with the court. So it's not insurmountable. It used to be a big problem. I also always put a notice, put a name on the card so that I know whose estate it is. When it comes to selling assets, it can be very tricky. The ideal situation is where you have a court where the personal representative is subject to very few restrictions. So what does that mean? When the judge signs off on letters of administration, it's generally a one-page form. Most places will have a stamp put on there that says the estate needs to close within 12 months. That's standard. Depending on where you're administering the estate, the stamps could be a lot more. And each stamp is a restriction. So you may see, for instance, in Florida, in Miami-Dade County, you might see a stamp that says or bond stamp on there because they're very restrictive. In other counties, you may not see that. So if I'm in, let's say, as it stands now, mostly in Palm Beach County, if there's a piece of real estate that a personal representative needs to sell, what they're going to do is they're going to usually get a realtor. They're going to put the property up for sale. They're hopefully going to get a good researched price because they may need to justify that to the beneficiaries. So hopefully they've done some sort of at least limited market analysis with a realtor to determine a good price. They'll put the property up for sale, sign a listing agreement, and then when they get a buyer, they'll sign the contract. If they're smart, they'll reach out to all the beneficiaries and let them know with a copy of the contract and have the beneficiaries sign off. Then they'll get the property sold, put the money in the estate account, and that's the end of it. If you're in a place where you have a restriction, the court may require an order approving the sale. The thing to be wary of is if you're going to be subject to that, you need to make sure, and I do this in any contract anyway, you need to make sure that there's a provision in the contract that notifies the buyer that there is a probate going on and therefore they are subject to any court proceedings and there might be a delay so that the buyer can't renege on the contract because of this, there's a delay with the probate court, and the buyer can't say it's a title problem because they've been informed about it. So I generally will put that in any contract for any estate property that's being sold because there's no downside to it. But if there's a petition required with the court, the personal representative is going to have to file a petition with a copy of the contract, often a letter from someone in the know, whether it's a realtor or an appraiser, that the price is an appropriate fair market value price. And then they may have to file consents by and joinders by the beneficiaries, and only then will they get an order. And depending on where you are, there's no time limit as to how long this could take. You may have to have a hearing on it. You may have to walk it through. It's going to be additional legal costs involved, and beneficiaries need to understand this. So if there's going to be real estate involved, there could be potential additional time lag and additional costs. In addition, you may not be able to sell until the creditors period has expired. Generally, we can sell and put the money into the estate account and just not distribute. The idea here is if they're going to be selling the property, you want to do your best to get it sold as soon as possible, because otherwise the estate is carrying the cost for the property. And every day that it sits there, the estate is losing money, and there's a potential for something to happen to the property. You also want to make sure that the insurance is kept up on the property, so that if something does happen, the estate is covered. And if the insurance company doesn't know that it's now in an estate, they could deny coverage. So you want to make sure that you let them know. And that would be the same with a car. Now, what's interesting with a car, and I don't know if this is something that's just what we have here in South Florida, or if this is in every state, but cars, you can usually go to the DMV with a copy of the will and get the car changed over either into the name of the estate or whoever's going to be receiving it. If not, then the title to the car needs to be found, and payments need to be made if the car is being financed. And then the car can be sold and title transferred and the money deposited into the estate account. If the car is leased, that's trickier, because often I've seen where the leasing company tries to collect the entire amount due on the car for the entire remainder of the lease. And it really depends on the leasing company, and it depends on how cooperative they're going to be. The concern I always have with a vehicle is that it is a liability and it is an asset, but more so a liability. If somebody knows that someone has passed away and there's a car sitting in the driveway, that car can be stolen. And if that car is stolen and something happens and causes an accident, potentially the owner of the vehicle, which is now the estate, could be liable. So you really don't want a car sitting around for any longer than necessary. But I can tell you from experience that while it makes no sense, often the leasing company or the finance company won't even speak to anyone until a personal representative is appointed. And if it takes forever to appoint a personal representative, they may not accept the payment of the amount that's due each month. So it becomes a huge problem, and these cars can then be repossessed. So you have to ascertain, is it leased, is it financed, who actually owns the car, and you need to kind of move on that as soon as you possibly can. Any other assets, like with regard to businesses, that can be very tricky. So while all this is going on, you need to make sure that there's someone in place to run the business and to run it adequately, because there's still people to be paid and there's a value to that business. If you don't have the proper people running the business, then the value of the business will turn to nothing very quickly and could end up being a liability. So the personal representative does have a responsibility here to really ascertain what the situation is in the business fairly quickly. Does a personal representative get paid? Well, the answer is it depends. There could be a provision in the will that says that a personal representative is not entitled to compensation. If there is no provision, then the personal representative in Florida is entitled to 3% of the inventory value, plus they can have additional fees if they do something over and above what a normal personal representative would do. And then it's going to be dependent on the court what they'll agree is a proper fee. The beneficiaries need to agree to this fee. Even though there's a statutory basis for it, they need to agree. This means that a personal representative who is thinking of taking a fee, and many, by the way, won't take a fee if everybody who's involved is a relative, but some will. If they're thinking of taking a fee, even if it's not sure but maybe, they need to be keeping very careful time records of what they do for the estate. Detailed records, how much time is spent, how much money they spend out of pocket and for what. Keep every receipt, Because in the end, while they may have thought they weren't taking a fee, if the beneficiaries end up causing them a lot of undue stress, in the end, they may choose that, why not? They did all the work. Why shouldn't they get a fee? And if they don't have the records, it's going to be hard to justify. So I always tell the personal representatives, if they're going to consider a fee at some point, or they're not definitely refusing one, they need to make sure that they have all the records in place. And anything that they do that needs to be reimbursed, they need to have those receipts. What's interesting is, even if there's only a single beneficiary and the beneficiary is also the personal representative, they still need to do this. The reason is, if there's an abundance of creditors, and I've had this situation, and the actual creditors, the actual claims are more than what's in the estate, in theory, the beneficiary has done all this work to get nowhere. But they are entitled to a fee, and they are entitled to reimbursement. And therefore, that's over and above what any regular claimant would be able to get from the estate. So at the very least, they'll be able to get a fee and reimbursement before any creditors are taking all the rest of the money. So once the personal representative has done this job, then it's time for them to close out the estate. Make sure any final tax returns are filed. Make sure all assets have been dealt with and distributed and sold. And then they file a petition for discharge with the court, saying that they've done everything they're supposed to do. They may or may not have done an accounting, which hopefully all the beneficiaries are going to waive the need for an accounting, because if you do have to have an accounting for an estate, that's going to be a large additional cost from the attorney and potentially the accountant. And that's going to be a record of income and disbursements, but it's really not that easy because it has to be in a certain format if you're going to submit a formal accounting to the court. And it has to be circulated to the beneficiaries for them to waive any objections to it. In most cases, the beneficiaries trust the personal representative, and they're willing to either go with just an informal showing of what the receipts and disbursements were, and they'll sign off and everything can move smoothly. But if not, you may need to have a hearing on it, and it's a lot of work to do that accounting, but it may be necessary. Once all that's been submitted to the court, you then follow whatever the final procedures are for your county, and you get a petition for discharge filed, and an order is signed by the judge, which discharges the personal representative from any further fiduciary responsibilities. Liability, and I mentioned this a little bit earlier, a personal representative is a fiduciary. They have fiduciary duties. If they fail to follow through on their fiduciary duties and they breach them, they can be held personally liable. So it's just something to think about if you're actually going to be serving as a personal representative. I always tell people it's not a good job, it's a necessary job. I always laugh when I see children getting offended when they haven't been appointed. It's not a fun job, and it's a tremendous amount of work. I've actually had one client tell me they quit their job so that they could do this full time because it was such an unbelievable amount of work. It doesn't have to be, and if you have a good support system and you have an attorney who will assist you and staff, it's not such a big deal, but it's going to depend on each individual estate, depending on what the assets are and if there's any problems that come up, because no two estates are ever the same. Let's switch gears and talk about the trustee. So if you have a trust, which is just basically a document that appoints someone to have legal ownership of assets for the benefit of the beneficial owners or the beneficiaries, they will have a trustee as part of this trust. You can have one trustee, you can have multiple co-trustees. It's all going to depend on what the document says as to what is governing body of this trust. You can have a revocable trust, which means that the person creating that trust, the settlor or grantor is what they're called, they can change the trust during their life and do whatever need be. They can terminate the trust, change it, take money from the trust. They're the ones who are generally the trustee in managing the assets. That's a revocable trust. The irrevocable trust is one that is either created upon death through a will or from another trust that triggers when a person dies, or it's created during the settlor's life for the benefit of others, but the settlor can't make changes to it or basically take the money back. The trustee has the duty to manage and protect and invest the assets. They then have a distributive power where they have to distribute the assets for the benefit of one or more beneficiaries. And we're going to talk about how the trust is it's divided into income and principal. The principal is the base amount of the trust and the assets, and the income is the annual amount that's earned on those assets. And the beneficiaries do not have to be the same for income and principal. And the trustee needs to know that, and that would be written in the trust itself and would give guidance to the trustee as to who gets what. If a trustee is not appointed, or there's a vacancy because whoever was the trustee is unable to serve, then there's either going to be a mechanism inside the trust that says who can appoint a new trustee and who can be appointed, what class of people can be appointed, or worst case scenario, that trust will not fail for lack of a trustee. They can always go and petition the court for the appointment of a new trustee. So just because there's no trustee doesn't mean the trust is going to have to terminate. The powers of the trustee are generally in the trust itself. Now, I've seen trusts that range from 3 pages to 110 pages. And a lot of the extra words usually revolves around the powers of the trustee. You could simply say that the trustee has the powers per statute in whatever jurisdiction the trust is in. Or you can list out powers. Or you can list out powers and break it down into real technical minutia. It's completely up to the drafter of the trust based on what the drafter feels, meaning the attorney, the trustee will do best with, and what the settlor wants to see. If you have somebody who really just doesn't want to read a long document, then providing them with a 50-page trust is not going to go over well. They're not going to understand it. In that situation, you're going to go a little bit shorter, and you're going to generalize the trustee powers a little bit more so that it's not too overwhelming to the client. The trustee will have a power to open bank accounts, to deal with any existing bank accounts, to sell assets, to contract. They can potentially have some power to modify the trust, but that's a nuance which we usually reserve for trust protectors or for the settlor if it's a revocable trust. Sometimes it's given to the trustee. That's a lot of detail. We have to discuss with the client and see what they're looking to accomplish. But the basic powers are buy, sell, manage, open accounts, make withdrawals, make distributions, deal with taxes, deal with advisors, accountants, attorneys, insurance, to be able to pay bills, to manage the assets the way a prudent person would manage the assets in similar circumstances. Those are the basic powers that a trustee has. You can, as I said, you can make them long, you can make them short, but that's really the basic powers. The trustee, like a personal representative, has to be over the age of 18 and has to have mental capacity. In general, and this is kind of a tricky point, but in general, the trustee, the beneficiary, and the settlor aren't the same person and can't be the same person. With that said, anyone who's ever seen a revocable trust would be saying, but wait a minute, I'm the trustee, I'm the beneficiary and settlor of my revocable trust. So how does that work? And the basic reason, the loophole, is that there are ultimately other beneficiaries after your death. And therefore, even though you fill all three roles, you are also the trustee over future beneficiaries. And that's how you get around it. In a testamentary trust, which is one that's created from a will, the settlor will then be deceased and can no longer be either a trustee or a beneficiary. So you wouldn't have that problem there. But the trustee has to have the capacity. They have to be able to manage the assets, and they have to understand what their role is. Because unlike a personal representative whose role is short-term from the beginning of the estate to the end of the estate, a trustee could have a very long-term role and a long-term relationship with the beneficiaries. The most important power of a trustee is to make distributions. Who gets the money and when? The trust itself should identify who the beneficiaries are and who receives the money, and whether they receive income and whether they receive principal. It should also give at least a general idea of when the trustee is to distribute the money. So we have our income, which is the money earned on an annual basis, and we have the principal, which is the base of the trust. If you have a very large trust, you can have it where only the income is being distributed and the rest of the trust, the principal, is building up, and it could last a very long time. You can have it where the income is actually not completely distributed and it does get accumulated, and therefore the trust again continues to build for the benefit of future generations to the extent that the trust is allowed to last, and that depends on state law. If you have income that is accumulated and not distributed, there are tax consequences to that beyond the scope of what I want to talk about today, but it is very important for the trustee to understand what the ramifications are of accumulating the income and not distributing it. In terms of making distributions, you can basically go one of two ways and kind of anywhere in between. There are two types of distributions. One would be a mandatory distribution, which is a requirement for distribution, which means if there is a mandatory distribution requirement, the trustee must distribute and does not have any real leeway to it unless there are stopgaps that say that a trustee, and you'd hope this would be in there, that there's a spendthrift clause and the trustee is not permitted to distribute where a beneficiary has creditors. There could also be provisions in there that say that if the beneficiary is an addict or a substance abuser, then distributions can be suspended. So there are times where mandatory distributions can be withheld, but in general, a mandatory distribution means the trustee must distribute regardless of whether or not the beneficiary should receive the money. So if they have a creditor, doesn't matter, depending on what the trust says, the trustee would have to distribute it and a creditor could take it. So there's really no asset protection in mandatory distributions. If you're looking for that and you're looking to protect the beneficiaries, discretionary distributions are the way to go. The trustee would have the latitude to make distributions as the trustee sees fit for the benefit of the beneficiary. That's, again, in my opinion, the better way to go if you're looking to protect your beneficiary from any issues that they may have. And if you're looking for dealing with beneficiaries that are not savvy with money, or if they're incapacitated beneficiaries, we can redirect discretionary distributions to be paid on their behalf, or potentially to a guardian or to some sort of special needs trust. One way of making it clear or somewhat clear how a trustee is supposed to distribute is something called HEMS. It's Health, Education, Maintenance, and Support. That's a very common standard that's used in trusts. And again, this can be a mandatory or discretionary distribution where the trustee knows that anything that's for health, education, maintenance, and support, the trustee can distribute. If you're going to go over and above that, for tax purposes, you're probably going to want to have what we call an independent trustee or a disinterested trustee to make those distributions because there are some tax consequences to it. We've already covered mandatory versus discretionary. Standards by which a trustee must abide. They have to manage the property with reasonable care as a reasonably prudent person would do. They have to avoid self-dealing, which means that if they are, let's say the trustee runs a landscaping business and there are properties within the trustee should avoid being the landscaper for those properties unless the trustee had other bids from similar companies and they were able to come out the best. You want to make sure if you're the trustee to have that in your file, because otherwise you can get sued later on for self-dealing. You also, as a trustee, do not want to be in a position to be in conflict of interest with those beneficiaries. So you have to be very careful, and sometimes when there's family involved, it could be a little trickier, but you want to make sure that you're in that position not to have a conflict with the beneficiaries. And then finally, it's your job to distribute principal and income in accordance with the wording of the trust. And just like with a personal representative, there could be liability that you're subject to. If you do something egregiously wrong, there could be civil penalties, there could be criminal liability. So watch what you're doing. If there are co-trustees, make sure you're all on the same page. And sometimes if there's a trust protector, that trust protector might be overseeing what you're doing. So you need to make sure that whatever you're doing it properly and you're keeping very careful records. When you do a distribution, I'm a firm believer in getting a receipt from the beneficiary that distributions have been made, just keeping very careful records because, again, the trust does go on for quite some time, so your file may need to be looked at. The trustee has similar duties to the personal representative, it's just a longer term. They have to manage the assets, they have to deal with the business. They have to, if there's public stock, publicly traded stock, they may have to vote those interests. They have to make the distributions, pay the trust bills, file tax returns, in which case, if it's a trust, there's going to be ongoing tax returns. Make sure they're always being filed and you're never missing one because there are severe penalties with the IRS. They may have to do annual accountings. It's definitely recommended to, at least on an annual basis, show the beneficiaries' income and disbursements so that never a question of what's going on with the trust. And they would want to collect receipts from any beneficiaries. And then if you're doing any work, whether it's for a piece of property or for sale of a business, you always want to get 3 bids because you want to be able to have that in your file if anybody would ever complain about it. How does a trustee get removed? So unlike a personal representative, which is kind of a one and done situation where they get in, they get out, hopefully within a year, the trustee can be an ongoing position. Trustees get older, trustees get, sometimes they start doing the wrong things and there could be potential breaches of trustee duties. Depending on what the trust says is how a trustee can be removed. Sometimes a trustee can be removed for no reason whatsoever, and that's called without cause, and it'll say that in the document. And it'll say who has the ability to remove the trustee and essentially appoint somebody else. Most often it says that the trustee can be removed with cause, meaning they've done something wrong or something objectionable. And just because it's not a crime doesn't mean that it's not a cause. So if they're no longer capable of performing their duties, if they've, gotten too elderly or senile and they can't do it, or it's just a physical incapacity, or they've materially breached one of their duties, or a conflict arises, If the trustees, if there's co-trustees, if they're having difficulty working together to manage the trust, and that's become a negative to the trust where they can't get anything accomplished, then potentially somebody needs to come out. And if the trust is performing so poorly in its assets that the trustee is really just not doing a proper job or hiring the proper advisors, potentially that trustee needs to be removed. Because the goal here would be that the trust would be a lasting situation, and you want to make sure that there's actual money in the trust. So if there's a cause to remove the trustee, then the trustee can be removed. If the trust itself doesn't really go into detail about it, the beneficiaries can always go to the court and request the court to intervene and remove the trustee and appoint somebody new. If you have co-trustees, that can go several different ways. It depends on what the trust says. If there's two trustees, then either they're going to have the power under the trust to act unanimously and do anything that they do for the trust on an individual basis without technically consulting the other trustee, or they can be required to act jointly. It might be more cumbersome to get things done, but it's a better checks and balances system. If there's more than two trustees, you can again have them act unanimously, which means all decisions must be made and signed off by every trustee, and they need to be in agreement. You can have an either-or situation where any trustee has the ability to make decisions solely on behalf of the trust, or what we normally see is a majority situation where if you have, let's say, 3 trustees, it requires 2 to make any decision. If you don't say so in the trust, it will be a unanimous decision. Sometimes that's kind of cumbersome. So you have to just think ahead when you're creating a trust. What are you looking to accomplish? Who are the beneficiaries? And if they're going to be the trustees, can they work together? Next, we'll talk about, and this is actually the last, is the trust protector. I'm not going to go too much into this situation, but a trust protector is another party that's involved in a trust that is often given some oversight powers. So they may have the ability to remove and appoint trustees instead of giving that to the beneficiaries. They may have limited amendment powers. So if for whatever reason tax laws change or there was a Scrivener's error in the trust, the trust protector might be able to make an amendment to a trust that was actually irrevocable. So there's a lot of flexibility you can have if you have a trust protector. What I like about it is it's a checks and balances system. The trust protector doesn't need to be part of the daily activities of the trust, but depending on what powers you give the trust protector, they can be the oversight. They can keep the trustee in line because the trustee knows that there's a trust protector out there who can look at what they're doing. They may be the one to examine the investments. They may be, the person that has the ability to change the trustee. So the trustee is going to have to watch what they're doing because you have a trust protector who's overseeing what they're doing. Okay, we're almost out of time. So if anybody has any questions on today's webinar, please feel free to email us, info@assetprotectionattorneys.com. If you have an idea for another webinar topic, we're always looking for webinar topics. So anything on estate planning or related thereto, anything on asset protection, that would all be great. Please let us know. If you're not already receiving our newsletter, which comes out weekly, it's the e-newsletter, let us know as well. And if you're interested in a preliminary consultation, complimentary, we're happy to hear from you. Thank you for joining us today, and please join us next month when we're going to be talking about LLCs and how they fit into asset protection. And the date on that is August 22nd at noon Eastern Time. Thank you so much for joining us today, and have a great rest of the day.